finally 26 years in the practice of law. My name is Attorney Joe-Santos Balagtas Bisquera. I have a Bachelor of Business Administration, major in accounting, and a certified public accountant, University of the East Manila, summa cum laude. I have a Master of Business Administration, MBA, University of the Philippines, Diliman, magna cum laude, valedictorian. My Bachelor of Laws, University of the East, cum laude, valedictorian. I immediately joined the corporate management sector in 1968 after I took the CPA board examination. Starting my career as a junior supervisor, a financial analyst, and ending it up after about 40 years in the highest level of a finance professional, Executive Vice President, Chief Finance Officer, and Corporate Treasurer. The multinational and local companies that I've been with would include Executive Vice President, Fuji Xerox Philippines in electronic printing and Xerox machines, Director, Finance and Administration of GlaxoSmithKline, at the time SmithKline and French Overseas Company, Pharmaceutical Industry. Finance Manager, Motorola Philippines in the electronics and semiconductor sector, Controller and Director for Financial Services of Delgado Brothers Incorporated, an integrated transport company. My first job was as a financial analyst of ESO Philippines, the local subsidiary of Standard Oil of New Jersey in the petroleum industry. Initially, I was a financial analyst handling the financial analysis, reporting, and budgets and forecasts for the refinery. I moved over for my training and first supervisory job in systems, administrative systems, and got my training in the US on a correspondence course on what we now call as IT or information technology. I became the supervisor of Bataan Refinery Accounting, and finally a senior supervisor inventory and cost accounting of then ESO, which became Petron. I have an MBA degree from the University of the Philippines that allowed me to teach MBA in Financial Management at the De La Salle University Graduate School for 35 long years and 10 years with the UP MBA in Diliman, teaching financial management. In the field of law, after I passed the bar examination in 1994, I immediately started appearing in court even when I was full-time finance manager of Motorola, appearing for criminal and civil cases before the Metropolitan and Regional Trial Courts of Metro Manila and the nearby provinces, handling labor cases before the labor arbiters and the National Labor Relations Commission, where my cases, civil, criminal, and labor cases, reached the Court of Appeals and won several of them before the Supreme Court. On the basis of my balanced involvement in business and at the same time in the practice of law, I was nominated in 2012 and 2016 given a public interview before the Judicial and Bar Council to be Associate Justice, Supreme Court of the Philippines. Today, I am Dean, College of Law, University of Manila, while at the same time Vice President for Legal Services and member Board of Trustees. At one time, I was also the Dean, College of Law, and Vice President for Legal Affairs, University of Perpetual Help in Las Piñas and Binyan. I have been a professorial lecturer of the Philippine Judicial Academy, the Supreme Court's training arm for judges handling criminal law and mercantile law. I continue to be active in the practice of law even today. I have been a bar reviewer and law professor at the University of the East, University of Santo Tomas, De La Salle University, University of Perpetual Help, San Sebastian, and Far Eastern University. To start the ball rolling, my dear friends, we shall again revisit my mental framework of remedial law, the biggest mortality in the bar examination, allowing only 1 out of 10 candidates all over the Philippines to pass remedial law, and even the top 4 schools of UP, Ateneo, San Beda, and UST managing only about 1 for every 5 of their candidates to pass remedial law. With utmost respect, I advance that the hypothesis that remedial law needs a major paradigm shift. Remedial law is the set of procedures in the rules of court that the Philippine judicial system follows to enforce established legal rights by prescribing actions and imposing penalties upon those who violate said rights. It is the unique collection of procedures which litigation lawyers, prosecutors, judges, and justices adhere to in enforcing the rights being violated versus society in criminal law and or individuals in civil law. Substantive law and procedural law are complementary aspects of the total judicial and legal system in the Philippines. Substantive law defines an individual's right, that means to life, to liberty, to property, which another person must recognize as his obligation to respect. Procedural law, in turn, would be the detailed steps in the judicial system to restore or compensate a person whose right was violated when an offender fails in his obligation to respect that right. Procedural law is a system consisting of a start when a right is violated and ends when said right is restored by a court judgment or order. Procedural law is understood and adhered to when the steps from the start are laid down systematically towards the end to reflect how the violated right is restored or how the person whose right was violated reacquires and or compensated for his deprived right. Philippine procedural law, my dear friends, embodied mainly in the rules of court, can stand major improvements in laying down, in a simple but systematic flow, the trial steps to achieve speed and efficiency. The rules of court needs to be rewritten along the process flow structure with a clear start and a decisive ending. Evidences to include testimonial, object, and documentary evidences are to be clearly shown in the process flow so there is assurance of easy and clear compliance. This is the major approach that I have adopted in several of these YouTube uploads that I am doing. It is unfortunate that I was not given the opportunity to join the Supreme Court as Associate Justice because had I been given at least only 2 years to be in the Supreme Court, I would have rocked the boat to rewrite the rules of court so that they would reflect, the flowchart process from beginning to end of both civil, criminal law, evidence, and all the aspects of Philippine procedural law to allow every person, from the judges to the prosecutors to the practicing lawyers, more so to the law students and law graduates, and to my mind, even the ordinary layman of the street, to understand the entire judicial system from start to finish and therefore expect a speedy disposition of justice. Having failed to achieve that opportunity, I am preparing these uploads on YouTube using precisely the flowchart methodology in order to explain very clearly the concept and steps in procedural law, and even if we can cascade this to the substantive laws that are on the table. The constant squabble among the local legal advocates and the presiding judge may be symptomatic that the procedural rules can indeed be confusing. Excuse me. The poor performance in remedial law of the bar candidates, where only 1 out of 10 nationwide would pass remedial law, and only 1 out of 5 of the top 4 schools will pass remedial law, may be indicative that what is being taught may not really be the fine-tuned not really fine-tuned to a speedy and systematically flowing judicial process, albeit recent amendments to the rules. To start the ball rolling on the component of evidence represented by the witness testimony, allow me now to present to you the following slides. First, we will focus on showing the 3 components of the trial process: the presiding judge, the prosecutor or the counsel for the complainant, and the defense counsel either for the accused or the respondent in a civil action. And here it is shown that the start of the process is the pre-trial conference, out of which the judge orders a pre-trial order to guide both of the litigants, the prosecutor and the defense counsel, or the counsel for the plaintiff versus the counsel for the defendant, to follow the pre-trial order by way of a systematic scheduling of the trial process. And so we now bring in to the picture In the middle of this battlefield, the witness, the first evidence that can be presented in any court proceedings. A witness is a person who can perceive, and perceiving can make known his perception to others. Religious or political belief, interest in the outcome of the case, conviction of a crime do not disqualify one to be a witness. On the witness stand in the open court, the witness is presented in trial or hearing for examination in open court, under oath or affirmation, to answer questions orally. Although it was worthwhile to mention that the Supreme Court managed to shorten significantly the direct examination of the witness with the introduction of the judicial affidavit rule. Going back to the requirement that a witness should testify in open court, this is consistent with the mechanism of justice and fairness that the accused is able to confront his accusers, the people who are suing him, frontally and in open court. However, there is an exception that the Supreme Court recognized in the case of Sarah Jane Veloso in the People versus Sergio Lacanilao case of 2019. You will recall that Sarah Jane Veloso is a poor Filipina recruited to become a domestic helper in Kuala Lumpur, Malaysia. And when the recruiters brought her to Kuala Lumpur in Malaysia, the job was not readily available, so they asked her while waiting for the job opening to come with them to Jakarta, Indonesia, carrying with her a bag that was only given to her before they departed for Indonesia. Upon arriving at Indonesia, Sarah Jane Velasco and her recruiters were apprehended, and when the bag was opened, inside the bag were significant quantities of prohibited drugs. That led to Sarah Jane being prosecuted, tried, and sentenced to die before a firing squad as judged by the Indonesian court. So Sarah Jane was waiting for her execution, but the Philippine authorities were able to catch her recruiters and were prosecuting them before Philippine courts. Unfortunately, the case against the recruiters were so weak because the major witness, Sarah Jane Veloso, cannot appear before a Philippine court to testify. And so the Philippine public prosecutors filed permission with the court to secure the deposition of Sarah Jane in the prison in Indonesia, to which obviously the defense objected by reason of the requirement in criminal procedure that a witness should appear in open court. The Supreme Court took exception when it allowed Sarah Jane Veloso's deposition in an Indonesian jail by reason that said witness cannot come to court under extraordinary circumstances. She's under detention and awaiting her final verdict of death by firing squad. The fundamental rights of both the accused and the state as a prosecutor must be equally upheld and protected so that justice can prevail in the truest sense of the word. To do justice only to the accused and not to the state is no justice at all. Justice must be dispensed with all the parties alike. And so, the deposition of Sarah Jane Veloso was taken and accordingly recognized before the trial court in the Philippines. Now, when a witness is put into the witness stand, that witness enjoys certain rights as well as obligations. There are 5 rights that a witness deserves. Number 1, the witness is to be protected from irrelevant, improper, or insulting questions and from hard or insulting demeanor. The usual harassing techniques of veteran lawyers in a court of law. Second, the witness is not to be detained longer than the interest of justice requires. The witness should not unnecessarily be burdened by staying in the witness stand longer than what is necessary. Third, the witness is not to give an answer which will tend to subject him to a penalty for an offense unless provided by law. And number 5, the witness is not to give an answer which tends to degrade his reputation unless it be the very fact at issue or to a fact from which the fact in issue would be presumed. But a witness must answer to the fact of his previous final conviction for an offense, because that would establish whether or not the judge would consider the testimony of said witness already convicted in a prior judgment to be a credible witness. It is very interesting to include in the discussion of the witness as an evidence the mandate of the Supreme Court on the continuous trial of criminal cases. In all criminal cases, the court shall after arraignment order a pretrial conference to consider the following. This is the major startup of any proceedings in criminal cases, and that is also true in civil cases. In criminal cases, the court shall consider the following components. Plea bargaining that may allow the complaining witness to accept a reduction in the crime being prosecuted to allow perhaps a speedier disposition of the case. Second, the counsels are encouraged to explore stipulation of facts where minor issues or issues that are not debatable should arrive at a certain compromise of stipulations or agreements by the two parties. Very critical is the marking for identification of documentary and object evidences. This takes a lot of time in the past when the documentary evidences are presented for identification only when the witness is already at the witness stand, and interruption for purposes of marking for evidence the documents and objects identified in open court. This is no longer the system. At the start of the pretrial conference, all the documents and all the object evidences to be presented during the trial should already be present during the pre-trial conference for purposes of identification and marking, and even the waiver of objections to their admissibility. And finally, such other matters as will promote a fair and expeditious trial of the criminal and civil aspects of the case. After the pre-trial conference has been conducted by the judge issues or the court shall issue an order reciting the actions taken, the facts stipulated, and the evidence or evidences so marked. Such order shall bind the parties, limit the trial to matters not disposed of, and control the course of action during the trial, unless modified by the court to prevent manifest injustice. Where a plea of not guilty is entered, the accused shall have at least 15 days to prepare for trial, which shall commence within 30 days from the receipt of the pre-trial order. Now, this is one way of already accelerating the trial process. Here, 15 days is given to the defense counsel from the time that the receipt of the pre-trial order. And the trial shall commence 30 days from the receipt of the pre-trial order. Now, the law on continuous trial of criminal cases, that is Republic Act 8493, implemented by the Supreme Court under Circular 39-98, has set a very specific time limit for trial. The criminal cases involving persons charged with a crime, except those subject to the rule of summary procedure or where the penalty prescribed by law does not exceed 6 months imprisonment or a fine of 1,000 pesos or both, irrespective of other imposable penalties, the court shall, after consultation with the public prosecutor and the counsel for the accused, set the case for continuous trial on a weekly or other short-term trial calendar at the earliest possible time, so as to ensure speedy trial. In no case, very, very important, shall the entire trial period exceed 180 days from the first day of trial, except as otherwise authorized by the court administration pursuant to Section 2, Rule 30 of the Rules of Court. There you are, my dear friends. In criminal cases, from the time the first witness is presented by the prosecution to the last witness by the defense, that should not be more than 180 days. In the latest amendments to the Rules of Court on civil procedure, what happened was the 180 days was further modified in that the counsel for the complainant is given 90 days or one half of the 180 days to finish his presentation of evidence, and the defense is also given the same 90 days to complete the presentation of evidence for the respondent. And so now we are talking of 180 days or no more than 6 months for that particular trial to be over. That's a very beautiful sign that we are serious in accelerating the disposition of cases in the Philippines. After all, justice delayed is justice denied. And so, what is the order in examining a witness in open court? There are 4 steps involved in the presentation of a witness. In a criminal case, the prosecutor handles the first salvo to through a direct examination of his first witness. That is followed by the defense counsel's cross-examination of that particular witness. The prosecutor comes back through a redirect examination to essentially make sure that the answers that could have been made weak in the cross-examination is amplified. And finally, the defense counsel comes back with his recross examination in order to strengthen his argument, disagreeing or disproving some testimony by the witness. After all the witnesses are through, then at the discretion of the court and to the motion of either counsel, some witness or witnesses may be recalled to the witness stand for clarificatory questions. Going back now to what is direct examination, of course, the witness is called, swear in, identified as to the name, and personal circumstances, and is asked whether she would be giving her answers truthfully, by taking her oath. And being the first witness on direct examination, the witness presents the relevant facts to the issue of the right violated through the direct examination of the prosecutor in a criminal case, or through the same questions by the counsel for the complainant. And this is by way of the direct examination of witness, and in today's rule, the judicial affidavit has shortened the direct examination. During the pretrial conference, it is the court expects that the prosecution would be presenting its judicial affidavit. The judicial affidavit of the defense counsel has been a contested issue by way of the defense arguing that the presentation of the judicial affidavit is premature because of the presumption of innocence of the accused, who does not need to defend himself because the burden of proof and the burden of evidence rests on the prosecution. With the judicial affidavit available, the public prosecutor would simply introduce the document and have it identified by the witness. And considering the judicial affidavit already enumerates the objectives for which that witness is being presented, the prosecutor now, therefore, rests his direct examination after the judicial affidavit has been identified. And once the direct examination for the first witness is done, the defense counsel is given now his time to cross-examine the first prosecution witness. The opposing counsel cross-examines the witness' accuracy, truthfulness, and freedom from bias, securing important facts on the issue of the right violated or not violated. The next round goes to, again, the prosecutor or the counsel for the complainant by way of redirect examination. The counsel presenting the witness re-examines him to explain or supplement the answer or answers given in the cross-examination. This is actually to refocus and to strengthen further the hypothesis that the prosecution or the complainant is presenting. The court, surprisingly in the rules now, may allow matters not dealt with in the cross-examination on redirect examination. In the previous rules, the redirect examination by the prosecutor would be limited only to the subject matter raised during the cross-examination by the defense counsel. In the current rules now, the court may allow matters not dealt with in the cross-examination on redirect examination. There you go, the redirect examination. And finally, the ball now comes back to the defense counsel for his cross-examination, where he may cross-examine the witness on matters stated in the redirect examination. The court may allow also other matters not dealt with in the redirect examination to be covered by the defense counsel. And so we now go into the witness himself. The witness can testify only to those facts which he knows of his personal knowledge derived from his perception. In other words, the facts that the witness is expected to lay down would be those knowledge, those perception that she achieved by the use of her sense of sight, by the ears, by the nose, by taste to the mouth, and by the skin by way of a feel. And in the process, therefore, this brings to focus the question of hearsay. Hearsay does not represent personal knowledge of the witness. And generally, hearsay, something that she heard somebody say it about a certain fact connected to the law or to the issue on the table, is not admissible in evidence. Hearsay is a statement other than one made by the declarant while testifying at a trial or hearing, offered to prove the truth of the facts asserted therein. That statement can be oral or written, or it can be a non-verbal conduct. And either of the two are intended as assertions. The hearsay per se is not admissible in evidence, again because they do not represent the personal knowledge of the witness in the witness stand. However, there are certain statements that are not hearsay. A declarant's statement made at the trial or hearing, subjected to cross-examination to prove the truth of the facts therein asserted, is a statement which is not hearsay. And the statement is inconsistent with the declarant's testimony given under oath subject to perjury at the trial, hearing, or other proceeding, or in a deposition. Consistent with the declarant's testimony, and if offered to rebut an express or implied charge against the declarant of recent fabrication or improper influence or motive. Continuing now, while the hearsay rule says that the testimony of a witness based on hearsay and not based on his personal knowledge would be inadmissible. However, there are exceptions to the hearsay rule, where even if it were hearsay, they will be accepted as part of the testimony of a witness in the witness stand. The first one is dying declaration. The dying declaration, or the declaration of a dying person, made under the consciousness of an impending death, may be received in any case wherein his death, yung kamatayan niya, is the subject of inquiry, as evidence of the cause and surrounding circumstances of such death. So, let us imagine now a case of homicide where the victim, before he passed away, whispered or said something to a particular bystander. And his declaration is, the person who killed me is this person standing holding that knife, who waited for me and without any provocation stabbed me. That's now I am dying. The bystander who listened to the dying person's statement has no personal knowledge of the truth of what the dying person is saying. Yet, when the dying person mentioned it to that bystander can be called in the witness stand, and even when he did not have personal knowledge of the actual killing by that accused, his testimony in the witness stand that the victim made that pronouncement about his death, impending death, pointing to the one responsible for his death, even when that is not personal knowledge to the witness. The dying declaration as hearsay from the dying person himself is admissible in evidence when the bystander takes the witness stand. A very interesting subject matter there is, it says dying declaration. What if you have a witness in the witness stand who is now testifying that she heard this dying declaration, but opposing defense counsel objected to the dying declaration because the one who gave the pronouncement as hearsay to the victim, to the witness, did not die. The person, therefore, can testify in court, and therefore his supposed dying declaration did not materialize into death. The dying declaration is relevant because if it concerned his death and he was able to mention it to the bystander, even if hearsay, that victim would no longer be around to testify about the cause of his death. But if the person did not die, then the attempt to kill him is a matter that he can himself relay in court by taking the witness stand. So the dying declaration would only be a valid hearsay when mentioned by a bystander when the victim in fact died. But if the victim did not die for any reason whatsoever, then the dying declaration does not serve its purpose because the victim can take the witness stand to testify. Another exception to the hearsay rule is that the statement is part of the res gestae. Res gestae. It is a statement made by a person while a startling occurrence is taking place or immediately prior or subsequent thereto, under the stress of excitement caused by the occurrence with respect to the circumstances may be given in evidence as part of the res gestae. I remember in the 1970s, at about 7 o'clock in the evening, we were then working over Tawad as management employees, as financial analysts of ESO Philippines, because we were rushing to meet the month-end January deadline to submit the financial reports of the company. Exactly about 7 o'clock in the evening, we heard and I saw a big explosion at the lobby of then ESO Philippines. That building is today the Insurance Commission. And suddenly fire was catching up on the building. We were I was myself having a meeting with the payable supervisor, Ben Baladan, when the explosion happened. And after realizing that there is danger for us, we asked the staff around there to jump off the window. Since we were on the ground floor, it was not very difficult even if the building was elevated. And so we were able to get out of our dilemma. Somewhere along the line, there was a bystander that saw three people approach the guard at the lobby, opened without the permission of the guard the sliding door, and threw in exactly something like a bag that led to the explosion while the three started running away. The bystander, who is the cigarette vendor in front of the building, shouted and said, yun po, ang mga naghagis ng bomba. On the witness stand, that particular cigarette vendor bystander would be giving a testimony which is part of the res gestae, which he mentioned while there was this explosion and while he was having a stress of excitement about the explosion. Does he have personal knowledge that the bag that was thrown by the three people running away were actually the bombs that exploded? The answer is no. He only saw the bugs. He never saw the explosion, neither did he saw that the explosion came from those bags. But his testimony is actually admissible in evidence because it did happen at the time that the startling explosion happened that excited him. And so that particular evidence is admissible. Now, assuming, for example, I was listening to him, I managed to go in front of the burning building and I heard him say, ayun po ang nagpasabog ng building. I can equally testify that based on that startling occurrence, this particular person I heard, mention that those three people running away were the perpetrators of that crime. My testimony is also part of the res gestae and admissible in evidence. Statements accompanying an equivocal or ambiguous act, material to the issue and giving it a legal significance, may be received as part of the res gestae. This is another interesting topic. There were two people who were confronting each other in a heated quarrel. And one of them raised his hand. Now, the raising of the hand is considered equivocal or ambiguous because his raising of hand could have proceeded to punch the other person, or it could have led to his scratching the back, his head. And a witness to this particular incident may mention that he saw this particular confrontation where one of them raised his hand. And that witness may give a statement saying that this is in his own evaluation that particular accused was really intending to hit the victim. Because the victim somehow withdrew and ran away, was about to run away when he stumbled and fell and his head, hit the pavement and he died. And so here is a particular case where the death of the victim could have been triggered by the raising of the hand. And another person may now interpret, this particular act, an ambiguous act, uh, that would explain his own interpretation of the intent, covered by, of course, other factors like he already knew that these two have been against each other for the past 6 months. They have quarreled in the past, but there was effort to stop their violent reaction to each other. Now, there are several other exceptions to the hearsay rule, such as the decedent statement or statement of a person of unsound mind, the declaration versus interest, the declaration about pedigree, and the family reputation or tradition on pedigree. All of these exceptions to the hearsay rule will be covered in the next YouTube upload because of time constraint in the preparation of this upload. Likewise, additional exceptions to the hearsay rule to be handled in detail in the next upload with the common reputation, records of regularly conducted business activity, entries in official records, commercial lists, learned treaties, testimony or deposition of former proceedings, and residual exception under Section 50 of Rule 130. All of this will be covered in due time in the next YouTube update. Continuing now with the disqualification of certain witnesses. And we can see on the witnesses stand a husband and wife newly married, where their marriage may be a disqualification for them to be a witness. During their marriage, which started in this picture, the husband cannot testify against the wife without the consent of the wife, the affected spouse. Neither can the wife testify against the husband without the consent of the husband. So, hindi pwedeng magbakbakan yung dalawa as witnesses against the other through a testimony. There are exceptions. The exception is the husband can testify against the wife even without the consent of the wife in a civil case by the husband against the wife. So it is the husband that is suing the wife on a civil case. And you can imagine this can happen in the annulment of marriage, because annulment of marriage is not a criminal case, it's a civil case, and therefore the husband, by obvious reasons, can testify against the wife to show that he deserves to get the grant of annulment of marriage on the basis of psychological incapacity. In the same way, the wife can testify against the husband without the consent of the husband if she filed a criminal case against the husband. So the testimony of the wife in a criminal case for a crime committed by the husband against her. And this can be, for example, an attempt to kill her by giving her poison. And the latter's direct descendants or ascendants, meaning the direct descendants, the children or the parents of the husband, and the children and parents of the wife cannot testify against each other or against each of them unless it is part of these exceptions. Again on marriage, but this time the disqualification of the witness is coming from privileged communication. So this one is personal relationship. The next one would be unprivileged communication. And during or after their marriage, the husband cannot be examined without the consent of the wife as to any communication received in confidence by one from the other, by the husband from the wife during the marriage. In the same way, the wife cannot be examined without the consent of the husband as to any communication received in confidence by the wife from the husband during the marriage. The exception is similar to the first one, where it is the husband who is the wife who's filing a civil case against the husband, where she can now testify, or the husband is filing a criminal case against the wife for criminal action, and the latter's direct descendants or ascendants. Okay. So on the case of marriage, the personal relations, and also the privileged communication. Third, speaking of lawyers, privileged communications would prevent a lawyer from being examined, from being asked to testify, where it is an attorney in the course of professional employment. So there you are, a lawyer in the course of professional employment. An attorney or a person reasonably believed by the client to be licensed in the practice of law. Ito na po yung mga pekeng abogado. That attorney cannot, without the consent of the client, be examined as to any communication made by the client to him or his advice given thereon. So take note that even fake lawyers are now bound to observe the rule on privileged communication. They are disqualified from taking the witness's stand. Now, there is also a beautiful feature here that an attorney secretary, stenographer, clerk, or other person assisting the attorney be examined without the client's consent and his employer as to any fact, the knowledge of which was acquired in such capacity. Pati po yung mga sidekick, yung mga assistants, hindi po pwedeng gagamiting espiya para makinig dun sa consultation, legal consultation, nung abogado at nung kliyente niya. They are equally covered by the prohibition covering privilege communication. However, the lawyer, the attorney, can be asked to be examined on any communication or advice that he was giving under the following 5 circumstances. 1. Furtherance of crime or fraud. When the lawyer, service, or advice was sought or obtained to enable or aid anyone to commit or plan to commit what the client knew, reasonably should have known to be a crime or fraud. So the lawyer was asked to help, but the act is for the commission of a crime. Then he can be asked to reveal the communication. Claimant to some deceased client, communication relevant to an issue between parties who claim to the same deceased client, regardless of whether the claims are by testate or intestate or by inter vivos transactions. So a brother and a sister, both enjoying the respective legitimes, can ask the lawyer to be examined on the communication coming from their deceased father, who is his client. lawyer-client breach of duty, communication relevant to an issue of breach of duty by the lawyer or his client or by the client to his lawyer. Obviously, when the client is suing the lawyer for disbarment, the client is obviously entitled to open up the communication learned. But more so, the lawyer, you know, can also be examined. He can actually testify on why he was not doing his duty as a lawyer anymore. The lawyer can say, my client is too naughty. He has been dating my legitimate wife. Okay. Now, the document lawyer attested to. Communication relevant to an issue concerning an attested document to which a lawyer is an attesting witness. Then the lawyer can be examined as to that communication or document. And finally, joint clients. Communication relevant to a matter of common interest between two or more clients. So you have two clients. If the communication was made by any of them to a lawyer, retained or consulted in common. In effect, he is a lawyer for both when offered in an action between any of the clients unless they have expressly agreed otherwise. So the general rule therefore is an attorney-client relationship creates a ban on the lawyer-attorney, even if he were a fake lawyer, to testify on communication between him and his client. And even his advice is not welcome in that particular regard. Another type of professional bound by privileged communication is a physician or a doctor. A physician in diagnosis or treatment of the patient's physical, mental, or emotional condition. A physician, psychotherapist, or person reasonably believed by the patient to be authorized to practice medicine or psychotherapy, meaning fake doctors, cannot, in a civil case, take note, civil case, without the consent of the patient, be examined as to any confidential communication made for the diagnosis or treatment of the patient's physical, mental, or emotional condition, including alcohol or drug addiction, between the patient and his physician psychotherapist. It is therefore axiomatic that the physician can be called to testify or be examined even without the consent of his patient in a criminal case where there is now the issue of the diagnosis and treatment of the patient's physical, mental, or emotional condition. This privilege applies to a person, including that patient's family members who participated in the diagnosis or treatment of the patient under the physician or psychotherapist. A psychotherapist is a person licensed to practice medicine, engaged in the diagnosis or treatment of a mental or emotional condition. Or a psychotherapist is a person licensed as a psychologist by the government while similarly engaged. Finally, in the sheet, the priest. A minister, priest, or person reasonably believed to be so cannot, without the consent of the affected person, be examined as to any communication or confession made to or advice given by him in his professional character, in the discipline enjoined by the church to which the minister or priest belongs. This has been for centuries recognized as the so-called the secrecy of the confessional. Continuing, the disqualification on privileged communication of a public officer. A public officer cannot be examined during or after his tenure as to communication made to him in official confidence when the court finds that the public interest would suffer by the disclosure. For instance, President Digong received an intelligence report that Joma Season, for example, is suffering from cancer of the brain. And so this is a very significant development that when Digong is asked, is it true that Joma Season is sick with brain cancer? Digong as a public officer cannot be examined while he's still president of such information given to him in official confidence. However, after 2022, when he's no longer president, may he be interviewed to be asked whether or not there is truth to the disease that is killing Joma Season. Again, as a public officer, he cannot be examined even after his tenure on communication made to him in official confidence. Communication shall remain privileged, even in the hands of a third person who may have obtained the information, provided that the original parties to the communication took reasonable precaution to protect its confidentiality. Moving now to testimonial privilege. And we have now parental and filial privilege. No person shall be compelled to testify against his parents, other direct ascendants, children, or other direct descendants. And the exception is the testimony is indispensable in a crime against that person or by one parent against the other. And so, moving now to the privilege, testimonial privilege, trade secrets. Ramon Ang, the chairman of San Miguel Corporation, is a person who cannot be compelled to testify about any trade secrets of San Miguel Corporation. The exception is the non-disclosure will conceal fraud or work injustice. Now, when the disclosure is directed, the court shall take protective measure as the interest of the owner of the trade secret and of the parties and the furtherance of justice may require. And finally, we have our witness on the witness stand in open court. In the conduct of asking questions, counsel is not allowed to ask leading question. A leading question is a question which suggests to the witness the answer which examining counsel desires. Questions that are answerable by yes or no. And this is where you will notice a veteran trial court practitioner versus an inexperienced new lawyer. In the matter of formulating questions, especially on direct examination. Good enough, there is now judicial affidavit. But without the judicial affidavit, there can be an issue on leading questions. However, in my experience, while the prosecuting counsel may be able to get away to the judicial affidavit of asking questions that are leading, when he goes back to his witness on cross-examination, again, he may be tempted or he may make the mistake of asking leading questions for which he can be ruled out of order. Now, what are the techniques by which a new lawyer can avoid asking leading questions and reveal his being a greenhorn practitioner? I remember my dear father, Captain Santos Vargas Bisquera, a military intelligence officer who taught me how to address issues that confront me as I get to be a mature person. He said, you know, anak, if you want to find out, the nooks and corners of an issue, you only need to ask 5 questions, and this is what is told us in military intelligence. The 5 W's. The first W is what. The second W is why. The third W is when. The fourth W is where. And the fifth W is it is what, when, where, why, and I am missing the last one W, but the corlatilla is how. You test that and you will see that you will not make a mistake of asking leading questions. So for example, you ask the witness on the witness stand, what is your relationship with the complaining witness? You are in the defense. And so that is not answerable by yes or no. And so the witness will say, she is my friend. And you now ask the question, in what way, what way did you become a friend? That is the question on why do you consider him a friend? That's another question, the why. The what, the why. And it says, she's my compadre or kumare. That alone would already allow you to weaken the credibility of the witness. Magkumpare, therefore, there is that kind of affinity and her testimony cannot be a neutral fact. And so you further ask the question, as kumare and as kumares, in what way do you show your mutual care and love for each other? And she would probably say, well, I come to her for help whenever I need one, and I also would help her when she needs help. In what aspect will that help be covered? In what aspect? For instance, does that include financial help? That is a leading question. And that can set a trap that the witness will say yes. And so the objection of leading question says, Your Honor, the question has already been answered, and therefore the objection is moot and academic. That's kind of thing you set up. And so there are so many examples I can share with you to actually solicit from the witness certain information that would question her accuracy, her credibility, her truthfulness. And therefore, you don't have to be under the mercy of asking leading questions answerable by yes or no. And obviously, you will be very sharp when the opposing counsel should be the one to bombard the witness with questions. Always test the question whether it's answerable by yes or no. And if it is answerable by yes or no, objection, Your Honor, leading question. And that is not allowed under the rules. However, having said that, there are instances when leading question is allowed. Number one, on cross-examination. When you are cross-examining the witness of your opponent, then you are allowed to answer questions by yes or no. So leading questions lahat. On preliminary matters, for example, you cannot introduce your evidence as fast. Then you ask for some preliminary matters from the witness answerable by yes or no. And so that allows you now, therefore, on your first 2 or 3 questions on preliminary matters, you can now set the rules on asking now questions that are no longer leading. There was one time I was in attendance as counsel, and I noticed that the opposing counsel is not a junior. He is a veteran lawyer. but he seems to be weak in asking these questions. And so, after about allowing him for 10, 15, 20 minutes, I raised the objection, Your Honor, please, counsel is not allowed under the rules to ask leading questions in direct examination. And he's been doing that for the past 20 minutes. And of course, counsel was very smart to react and said, Your Honor, preliminaries. Your Honor, and I said, if this is the trend on preliminaries, we probably will end up this entire testimony when all of them are preliminary matters. So with continuing objection, so the court cautioned the counsel, please change your, modify your questions. Modify your questions. The judges now are very smart. They don't anymore embarrass lawyer by saying objection sustained or objection overruled. In that case, the judge is saying objection sustained, but instead of saying that, he says, counsel, modify your question. And that's very good. That was part of the training of our recent judges now, allowing the lawyers to save face. There was another counsel, when I questioned the asking of pleading questions, who also said preliminaries, Your Honor, and I said when substantive questions are already being raised, Your Honor, there cannot anymore be preliminary questions. Now, next, where leading questions are allowed, you can ask leading questions when the witness is an unwilling or a hostile witness, meaning the witness is obviously on the side of your opponent. Then you can ask permission from the court, leave of court to now ask leading questions because the witness is a hostile witness. The same is true of the next one, which is of a witness who is an adverse party, of an officer, director, or managing agent of a public or private corporation, or of a partnership or association which is an adverse party. Again, you can now, this is almost the same as a hostile witness. Except here, this is obviously a hostile witness already because he is an adverse party that you put into the witness stand. And finally, when there is difficulty in getting direct and intelligible answers from a witness who is ignorant, a child of tender years, is of feeble mind, of a deaf mute, And so therefore, you can ask leading questions. Finally, when we speak about leading questions, there is also such a thing as a misleading question. A misleading question is a question which assumes as true a fact not yet testified to by the witness, or contrary to that which he previously stated, and this is not allowed. You watch out for this because some lawyers are very smart in planting, testimonies on your witness, and if you are not sharp, then that particular planted testimony would now be part of the records. The technique on misleading question is to make the witness believe that he already said something that he never testified to. Like for example, your opposing counsel will say, in the last hearing, Mr. Witness, you did admit you were with the accused person. Now, there was no such testimony and you now raise the issue objection, Your Honor. That is a misleading question because my client did not testify to that. And so your opposing counsel, insistent on the question, says, but Mr. Witness, is it not true that this is on cross-examining? Is it not true that you were with the accused? Objection, Your Honor, no basis. Meaning, that's a misleading question. What is his basis of saying that my witness or this witness is with the accused? No basis. And so the court will now say, lay down your premises. So then you say, the laying down the premises is it not true that yesterday you were in the office? Yes, Your Honor. And is it not also true the accused is in the office? Yes. And is it not true that you took merienda? Yes. And in the taking of the merienda, you met each other at the cafeteria and you sat in the same table. The if the witness is brave, she will deny under pain of perjury. But what if you have witnesses that would show that they were together? Then he will be afraid, and so he will now say, "Yes, we were together." So you confirm. So you're back to your original question, which was objected to as having no basis, that you were together yesterday. Okay. So these are some of the examples of leading and misleading questions. This is our, my dear friends, this is our second round of uploaded sharing on the provisions of the amended revised rules on testimony. There are still a number of items concerning the witness as an evidence that we have not covered. And some of them we did enumerate in terms of the exception to the Hearsay Rule. There are other components that we will pick up in the next upload, which will now include the discussion on documents as evidences, which will touch on the originally labeled best evidence rule, which now has been correctly relabeled the original document rule. And there is a redefinition of what comprises an original document. So we will have that in the next upload, my dear friends. Meanwhile, I'd like to thank you very much for allowing me to share with you this little piece of knowledge coming from the amendments, the revised rules on testimony, on evidence. And I am very happy to always have the opportunity to share with you this information. For my fellow lawyers, practitioners, I would welcome any suggestions or should there be any miscues or mistakes that I made. Please make a comment here, or if you can reach me out through text or my email, please do, and I will definitely recognize any needed corrections with acknowledgement of your effort. For my own clients, I'm very happy that you're watching your counsel here demonstrate that he knows what his business is all about. And for my law students at the University of Manila, continue to watch this particular uploads because this is our modification in the online learning process where we upload our lectures, allow you to keep on watching them because repetition is the key to mastery of the subject matters. And then we have our Saturday online sharing where you can ask clarificatory questions or I can even further amplify what I explained. But most important, in addition to that, I welcome all law students all over the Philippines. This is for free. Watch it, make any comments on it, and make any suggestions, any observations, because you are one of the most important components of my own wish to see more competent lawyers join the ranks of the legal profession, including my bar warriors from the University of Manila. But most of all, I dedicate this to all Filipinos who, if you ask, have at one time or the other aspired to be lawyers. Probably you talk to 10 people on the street, and after they overcome their shyness, they would probably whisper to you, Dean Bisquera, once upon a time, I wanted to be a lawyer. but I did not have enough money to go to law school. I am very poor. I did not even finish college. Some would even say I did not even finish high school. And so I can only look up with envy on those of you who are called attorneys at law. And perhaps with these lectures that I share with you on YouTube, even with your cell phones, you can watch this. And even when you do not have the degree of Bachelor of Laws, even if you are not called attorney at law, at least you can speak intelligently to a lawyer because you know the law. I know many of you, and I was also like you. I have been insulted so many times in the past because I knew my law. And when I speak to lawyers and they get embarrassed that I know something more than they do, they simply challenge me and say, bakit? Abogado ka ba? And so I had to wait for 47 long years, 25 years after I finished my Bachelor of Business Administration, to finally not surrender and go back to law school at an old age of 40 years old with a warning from my cardiologist that I will die in law school. And that was supposed to be when I was 40 years old, up to when I passed the bar when I was 47 years old. Today, while I refuse to reveal my true age to you, I can assure you that I continue to be alive and kicking. And now I can feel comfortable that my marker at Manila Memorial Park, put side by side with my grandfather and my father, would now have the title Attorney Joe-Santos Balagtas Bisquera. Except in 2004, the University of Manila was kind enough to affix to my title the very complimentary title of Dean College of Law. Now they will have to amend a little my wish to call me now Dean Attorney Joe-Santos Balagtas Bisquera. And to all of you, my fellow countrymen, my kababayans, from the Ilocos region, up to Zamboanga del Norte in Dipolog, up to Davao, up to Cebu, I dedicate this particular YouTube uploads for those of you who have always wanted to be lawyers but were not lucky enough as me to have the guts to go back to law school. I dedicate this to you, and perhaps while you may not be able to carry the title attorney at law, you can somehow get all the knowledge of law from me through these uploads. And when you are asked, are you a lawyer? You can say, I represent Dean Attorney Joe-Santos Balagtas Bisquera. He is my lawyer and I speak for him. Sa inyo po mga frustrated lawyers all over the Philippines, I love you. I'm so proud of you for you to master the law through me, and I will always be here. Send me a text, send me an email, or put some comments here if you have any questions about the topics that I am covering. Yung mga kaibigan ko po, dito po sa baba, meron po nakalagay na subscribe. Bago po nyo iwan itong YouTube na ito, pakipindot lang po para malaman ng YouTube na marami naman akong kaibigan na nanonood sa akin. Thank you very much. I'll see you soon again on the third wave of our discussion on evidence based on the amended, revised rules of evidence. Marami pong salamat. Have a nice day. Enjoy the rest of the week. Bye-bye. Thank you.